Good morning. So my name is Christina Estes-Werther, and I'm General Counsel here at the League of Arizona Cities and Towns. And this is the open meeting law presentation. So this is a lengthier presentation than what we sometimes do around the state. So it's going to be very thorough, but I'm going to show you sort of the overview of the items that we're going to address. And you can always skip ahead if maybe you're just looking for a refresher on a particular topic. Otherwise, this should be, again, very thorough and hopefully get most of your questions answered. If you do have questions that after the presentation that you still need to be addressed, please, you can go ahead and email me anytime. My information's on one of the second to last slides, my contact information, phone number, and email. And so you're more than welcome to go ahead and email me or call with any questions. If it's a very specific question, like something's happening in your city or town, it's probably best to talk to your attorney first, and then you can always have your attorney contact me. But if it's just a general question, you're more than welcome to contact me. So let's get started. So again, this is the presentation overview of what we're going to be covering today. So the first is I like to always touch on the legislative history and kind of policy of why we have the open meeting law. This just kind of helps us understand moving forward sort of why we have the specific provisions in the law. Also, I just want to touch on the definitions so that you understand how the open meeting law applies, and then meeting requirements themselves, so notice, agenda, minutes, and then also what you can do in an executive session. And then we'll touch on violations and penalties, and then any additional resources. I also have highlighted here House Bill 2065. Now, this was a law that was just recently passed, and it's not effective yet. We don't have the effective date. It'll be sometime the summer of 2018, but you'll see sort of this exclamation point on some of the slides, and this is just to let you know what's going to be coming ahead, and that, again, during the summer of 2018, it's going to be in effect, just so that way you have all the information going forward. Okay. So for training materials, what are your responsibilities? And this is really for the clerks. So the clerk has to conspicuously post the open meeting law material prepared and approved by the Attorney General on their website. So every city and town has its own website, and the materials approved by the Attorney General are actually very simple. They produce a handbook. And so what typically happens is the clerk can go ahead and post a link to that handbook right on your website, and that takes care of this requirement. Or maybe your city or town attorney has developed other materials that have been approved by the Attorney General's office, and so those might be posted as well. So as a city council member or town council member, it is your responsibility to make sure that you review the open meeting law materials at least one day before you take office. So that actually is in the law that you are required to read through those materials. So what is the purpose of the open meeting law? So it's the public policy of the state that meetings of public bodies be conducted openly, and that notices and agendas for those meetings contain information that's reasonably necessary to inform the public of what you're going to be discussing. So anytime there's any doubt of whether or not something should be interpreted with regard to the open meeting law, you always want to favor sort of that openness and transparency. So this whole public policy statement that I just read, it really guides the entire council. So whenever you're having council meetings, even advisory groups or subcommittee meetings or work sessions, this always kind of, again, guides you and lets you know that you always have to be in favor of being open and transparent to the public. And it just offers a reminder that, again, if you're having any ambiguity, you should always be open. So let's walk a little bit through the legislative history. So I'm not going to go through all the details of every single enactment, but I at least wanted to touch on a few just so that you could see sort of how the law has been interpreted and then how it's been changed over the years. So first of all, the open meeting law was actually enacted in 1962. So it's been in place for 50 years. And for a long time, we just had some interpretation by the Attorney General. And so you can kind of see all of these opinions here. And there were just specific questions that were coming to the Attorney General about how to interpret the law, because at that time it was a newer law. So in 1974, they did a big amendment to the open meeting law. They expanded the definition of governing bodies, which affects us as cities and towns. They added the definition of legal action, which we'll discuss in a moment, and they require the taking of written minutes, and they added some public notice requirements. They also clarified what you can do in an executive session, and then they added some provisions relating to violations. So that was a big amendment in 1974. We've also had some other revisions. In 78, again, they expanded the law to include advisory committees. And then in 1982, again, made some minor changes to the law. And then in 2000, they expanded it again, the definition of meeting to include technological devices. And we'll talk about that more because we actually, House Bill 2065 touches on that as well. In 2006, they required some jurisdictions to start posting their notices and agendas on websites. In 2008, they specified when a member of the council is not subject to meeting law if they're expressing an opinion through the media. And then in 2010, they're requiring the posting of notices online. So the important thing to know about sort of that legislative history and why I go through it is that if you look through all of those, essentially every time the open meeting law is changed, it's always changed in favor of more transparency, and it's always changed so that way the public have more access to their members. And so just kind of keep that in mind. You know, we have that underlying purpose that we have to be open and transparent. And again, anytime the law is changed, it's always reflected in those changes. So how does the open meeting law apply? So this is kind of the breakdown that kind of helps you understand whether or not the open meeting applies to your situation. So the first question you have to ask is, are you a public body? Now this does include advisory and subcommittees, and so we'll talk about that. And then the second question is, are you meeting? And so you have to then ask yourself, is there a quorum of the public body that's gathering? And is the quorum taking legal action? So we'll kind of go through these step by step. So what is a public body? So this is essentially the definition that's in statute. You see it's quite lengthy, and I've kind of highlighted what really applies to us. And so that's all boards and commissions of political subdivisions, and that's also political subdivisions themselves, and even multi-member governing bodies. Essentially all of these reflect that a city or town is a public body. So we kind of have the answer to that first question. So kind of delving in further, so a public body also includes all standing, special, or advisory committees or subcommittees. And so we do get questions sometimes of whether or not some of these sort of smaller subcommittees are actually subject to the open meeting law. And this is the specific definition in statute, and I've actually broken it down here to make it a little bit easier to understand. So if you're looking at an advisory committee or a subcommittee and you want to know if they're subject to the open meeting law, you have to look at how are they designated. Did the public body or the presiding officer officially establish the committee? And is the committee tasked with providing a recommendation to the council about a decision or a course of conduct? So if the answer is yes to both of those questions, then it is a public body. So we've also had some specific questions over the years of whether or not it matters if the open meeting law applies if maybe some members of the council are serving on the subcommittee. So the answer, and this is per the Attorney General's opinion, is yes, the open meeting law applies. And this is regardless of whether or not the subcommittee is made up of council members in whole or in part. So again, it really has nothing to do with sort of who is on the committee. It goes back to those two questions, whether or not the council or the mayor, they actually, assigned that particular subcommittee, and whether or not that committee is going to come back and provide a recommendation of a course of action to the council. So again, those are really the only two questions you have to look at when you're trying to decide if a subcommittee is subject to the open meeting law. So we've kind of walked through that definition, that first part, and this is kind of the easy part, right? So are you a public body? Again, as a city or town council, you are a public body. And again, that test is in place if you're trying to determine whether or not there's an advisory or subcommittee that is subject to open meeting law. So I do sometimes get questions about advisory and subcommittees. So it doesn't matter what you call it. You could call it a work group or a task force, or it doesn't matter. However it's designated is not really a factor. And we do have sometimes some staff members, let's say your city or town manager, wants to create a small group, a working group, to kind of help them with some of their workload. Well, your city manager is not the presiding officer of the council, and so that would not be subject to open meeting law. So again, you always have to go back to, is it the presiding member of the council that's actually forming that committee? And then are they coming back to the council, not a staff member, but the council, to make a recommendation for a course of action? So the only thing you really have to be careful about is obviously you don't want to try to circumvent the open meeting law by essentially having your staff create these groups, and that way it doesn't have to be subject to open meeting law. But if you do have a legitimate need, like your city or town manager, or maybe your financial advisor or another staff member, that they are forming a small work group to help them with their specific work, then that would not be subject to open meeting law. So, okay, so now that we have the first question answered, are you a public body? The second question we have to look at is, are you meeting? So first we have to look at whether or not there's a quorum of the public body gathering. So a quorum is a majority of the full membership of the council, and this is actually based in Title I in statute, unless otherwise noted. So for most of the, I would say most of the councils or all of the councils, it really is a majority of the full membership of the council. That's a quorum. Sometimes when some of these smaller committees are formed, if they have any type of guidance documents, in those documents, you could always specify a set number for a quorum. Typically, that can make it difficult if you ever have vacancies, and so most people use the default of majority. But unless otherwise noted in any type of governing document or statute, the quorum is always just the majority of the full membership. So let's look at how quorum is affected by vacancies or disqualifications, since we sometimes get those questions. So vacant positions do not reduce the quorum requirement, and this is coming from the Attorney General's Agency Handbook. So for example, let's say you have a 7-member council and you have 2 vacant seats, so you only have 5 members. Well, your quorum normally for a 7-member council would be 4, because that's the majority of the membership. And even though you only have 5 seated members because of the 2 vacancies, you still have to have 4 members for a quorum. Same thing goes for the second example. You have a 6-member council, and again, there's only 5 seated members because there's 1 vacancy. You still have that same 4 members that are required for a quorum. And so this can cause a lot of challenges if you're trying to obviously get together for a meeting. But you have to realize the underlying purpose of that is the law really wants you to fill those vacant positions as soon as possible. So this is sort of an incentive to make sure that you sort of don't lag and that you actually get those positions filled. So what about disqualification due to a conflict of interest? So sometimes you have members who are, let's say an item comes before them, and let's say they're part of a business and they would be, they would benefit monetarily based on what's coming before them as a council member. Well, so they would recuse themselves from, they disclose and say they have a conflict, and then they recuse themselves from that vote. So a disqualified member present at the meeting, they can't be counted for quorum purposes, but it's only for that particular matter for which they're disqualified. And so if you have other items on the agenda, and that person can count for quorum if they're not disqualified. So this is something that you'd probably want your attorney to kind of help you out with. But essentially, they're only disqualified for that particular matter in which they declared a conflict. So the example I have is that 7-member council has 4 members. So again, that's quorum, but one of them has declared a conflict. So again, they cannot proceed on that particular matter until another member attends. And this is actually based on case law, and I do have that case cited there. So what if the majority of the council is disqualified? So it's impossible, essentially, to convene a quorum. So this is rare, doesn't happen very often, but it could, especially in some of our smaller towns. And so the disqualified members must disclose on the record why they're disqualified. So that's always the first step when you're disclosing a conflict. But they can proceed to act as if they were not disqualified. And that's essentially because we need government to continue to function. And so if everybody is essentially conflicted out, we still need government to go ahead and make those decisions. So it's important to still disclose your conflict, and then you can go ahead and proceed. Okay, so let's look at the next about legal action. So the gathering in person or through technological devices of a quorum of members of a public body at which they discuss, propose, or take legal action, including any deliberations by a quorum with respect to such action. So this is the current definition of meeting in statute. And so we'll kind of talk a little bit more about legal action in a moment, but you'll see here that I have that House Bill 2065 flagged because it expands the definition of meeting. And essentially, it includes one-way electronic communication sent from one member of the council to a quorum of the other members, and that proposed change of electronic communications among a quorum of the members of the council that involves a discussion, deliberation, or legal action on a matter that may likely come before the body. Essentially, House Bill 2065, this expanded definition, is something that we've already been teaching for a long time, was part of the definition of meeting because it comes from an attorney general opinion. And so we've always kind of used that as guidance anyway. And so this really shouldn't affect anybody's interpretation of what a meeting is. This is now just codifying that attorney general opinion. And partly, I think the attorney general's office moved in that direction because this is kind of the direction that most of us are going into. We're actually going into more and more electronic communications and using more technological devices. And so I think they just wanted to be sure that everybody understood that factor is important when you're considering whether or not it's a meeting. So what is legal action? So you've kind of seen this referenced several times. So legal action, the definition is a collective decision, commitment, or promise made by a council pursuant to maybe either the Arizona Constitution, if you have a charter, your bylaws, or your code, or any type of specified scope of appointment and the laws of Arizona. So that's essentially the definition of a legal action. And all legal action of public bodies has to occur during a public meeting. So we'll talk more about this because legal action can sometimes be hard to understand. So legal action is really essentially all your discussions, your deliberations, considerations, or consultations that may foreseeably require some type of action by the council. And so really it's very all-encompassing. It's really sort of any matter that might be coming before the council that you might be voting on. So let's look at how the open meeting law applies. So again, we have that a city or town, and likely most of your subcommittees are a public body. So that was that first question that we answered. And the second question was whether or not you're meeting. And so we talked about quorum. So do you have a quorum of members that are gathering? And this can be in person, by phone, by some type of online medium, or chats, email, etc. It doesn't really matter how, if you have a quorum of members that are gathering. And are you discussing, proposing, or taking legal action? So is the matter that's being discussed or deliberated or proposed something that could result in final action by the council? And is the matter within your essentially scope of work or your purpose as the council, stemming from what it is that you do? So if the answer is yes to those underlined questions, that you do have a quorum gathering and you are discussing, proposing, or taking legal action, then it is a meeting under the definition of the open meeting law. And so if you are a public body, which you are, plus you are meeting, then that's how you know that the open meeting law applies. So this is kind of just a little diagram that I think kind of helps so that you can kind of understand whether or not the open meeting law applies to your situation. So the first is there a quorum? So again, maybe no. Maybe there you have a 7-member council and there's only 3 of you and you're meeting at a coffee shop. So there's no quorum, there's no meeting, unless you're splintering, which we'll talk about in a moment. But let's say you do have 4 of you there. There is a quorum. Are you discussing, proposing, or taking legal action? Well, if you're not, let's say you're actually just at a social event and you're not discussing anything council related, then no, it's not a meeting. So yes, you have a quorum, but you're not taking any legal action. And so again, it's not a meeting, not subject to open meeting law. But let's say you do have a quorum and you are discussing, proposing, or taking legal action, then yes, this is a meeting under the open meeting law. So I have some examples here, and I think this kind of helps sort of elaborate how the law applies. So is it a meeting if 4 members discuss a council matter by phone? So again, this is for a 7-member council, so your quorum is 4. So in this situation, the answer is yes. So you have 4 members, they're, again, that's a quorum, and you're talking about essentially a council matter, which is legal action. And so you have those 2, and it is a meeting. What about if you have 2 members who are in person, just sitting, chatting with each other? They are talking about a council member, and on speakerphone, they have 2 other members on the phone. So again, the same situation applies. It doesn't necessarily matter sort of if you're in the room together, because technological devices are actually a factor. And so if you have 2 members in person and 2 members on the phone, you still have 4. You still have that quorum, and you're discussing a council matter. And so it is a meeting. And let's say you have at least 4 members and they're on an email discussing a council issue. So this is where actually most people get in trouble inadvertently. So email, again, is included when you're talking about gathering in terms of a meeting. And so even though, let's say, you have a 7-member council and maybe 4 of the members are on an email discussing a council issue, which is a meeting, and you're one of the 5th, 6th, or 7th council members that maybe is getting copied on all of these, but you're not responding, that's still technically an open meeting law violation because there's a quorum of members that are discussing council action essentially behind closed doors. So this is where it's really important that all of your council members are educated about what not to do, especially when it comes to email, because it's just so very easy to commit a violation with email. So what about if you have 4 members who are at a social event discussing matters unrelated to the council, so not legal action? Again, maybe they're at a social event that has to do with a parade or with a festival or just something in your town, and they see each other and you know that they're together. Or often, sometimes this occurs at the league annual conference. You'll have obviously a lot of members of your council that are attending, but again, they're not really there to discuss council business. They're there to attend a conference. And so in this case, no, it's not a meeting because they're not taking legal action, even though there is a quorum present. Let's say you have 3 members that are on the phone discussing a council matter. So in this scenario, again, 7-member council, you need 4 members in order to have a quorum, and you only have 3. So you do have 3, and they are discussing a council matter, which would be legal action. But again, you're missing that 4th for a quorum. And so technically, no, this is not a meeting. But this is where you have to be very careful, because if just one of those 3 members essentially talks to another member of the council and sort of relays everything that you've discussed, what you've done then is what we call splintering the quorum, and you essentially then are in violation of the open meeting law. So this is where you have to proceed very carefully. So splintering the quorum is separate or serial discussions with the majority of the members of the council, and this is prohibited. And so what they mean by that is that you're maybe having, again, just very small or separate discussions with members, with fellow members, rather than sort of all getting together and having a quorum. But you're essentially trying to circumvent the open meeting law. And this can happen either by email, again, by any technological device, obviously by phone or text messaging, polling, which means that if, let's say you as a member of the council just go to every other council member separately to see how they're going to vote on a matter, that would be considered a separate or serial discussion. And so you also cannot direct staff to communicate in violation of the open meeting law. So you can't ask like your manager or your clerk to essentially do what you can't do, which is to then go poll everybody so you know how they're going to vote ahead of time. So that's just something to be aware of, again, when you're kind of looking at quorum and making sure who it is you're talking to and maybe what they'll do with that information. Okay, so we have a couple examples here of splintering the quorum. So is it a meeting if one of the 3 members on the phone texts the 4th member about the discussion? So again, this is a 7-member council where 4 members are a quorum. So if you have essentially 3 members, that's not a quorum, but they're texting a 4th member about the discussion. So yes, if it's about a council matter and it's legal action, then yes, this would be a meeting. So even though they weren't together at the same time, those four, if that one of those three members is relaying that information to a fourth, then this would be an example of splintering the quorum. What about if you have two members who discuss council business via email with, again, all members copied on the email? So you have the entire council that's being copied on the email, but it's really only two members who are going back and forth discussing legal action. Again, the Attorney General's office would still look at this as a violation, even though you may not have said anything in the email, and I know how frustrating that can be. That's why we always try to steer council members away from actually directly replying to any other council members, because it could just be easily forwarded. This is where you really want to rely on your staff member. Let's say you have three members who are discussing council issues via email. So again, not a quorum, but then they ask a staff member to forward that discussion to a fourth member. So essentially they're going to get that whole chain of emails and see the discussions and deliberations and consultations. So again, this would be a meeting and you would be splintering the quorum. And so this is, again, where you just have to be careful with how many people you're talking to. Okay, so let's see. Is it a violation if a member of the public emails the council and there's no further emails among members of the council? Well, so no, this is not a violation. Obviously, we want to have the public contact you, and they are more than welcome to go ahead and copy all of you on whatever it is that they're discussing. So again, the tip here is you just don't want to reply all. Even if it might not end up being a violation, it's just really easy for an inadvertent violation to occur down the road. So you just don't want to hit reply all. If you want to respond to that constituent, you probably just want to respond to them singly. What about if a council member requests information for staff for specific information and other members are copied on that email? So let's say that you're in a, you hear that there's a piece of legislation that's moving through that might impact you, and you want to get a copy of that legislation. And so you email the staff for that information and you do copy the rest of the council members on that email. So that is not a violation of the open meeting law because you're just requesting that information. But again, we would just highly discourage any email that would actually encompass all of the council members. Again, just because it's just very easy to inadvertently start replying all and then getting into a discussion or consultation. And again, you have that quorum of members on the email. So we would always just discourage doing that, like, perhaps use your staff member or respond to them just individually. But in this case, it is not a violation. What if the staff member replies to the council? So let's say they get that legislation and then they respond back to the council. Again, that's not really a violation. They're just providing information to the full council. But this is where I mentioned if members reply all to the staff member's communication, and let's say they ask for more information. Let's say they know that there's a lawsuit that's been filed with regard to the legislation. Again, asking information in itself is not a violation, but you're just sort of going down a dangerous path. So what about, is it a violation if a council member asks staff for a copy of legislation and copies the council on that email? So that was the example I gave earlier. So no, right? This is fine. It's not a violation just to ask for information. But if a council member hits reply all and they ask for, maybe at this time it's an attorney general opinion relating to the legislation. Again, not so much a violation. They're just asking for information, but we would highly discourage you from hitting reply all in the future, because this could lead to a situation in the third bullet, which is a council member hits reply all and suggests that the council file a lawsuit against the legislation. So this is where essentially now you've violated the open meeting law. And you might ask, well, how did we get to that point? So essentially asking for information and providing background information or staff providing it to you is okay. But essentially in this third bullet, what we've seen is that now a council member has proposed legal action. They've proposed a lawsuit in response to this legislation. And all of the members of the council are, on that email. So you have a quorum, legal action has been proposed, and it's not been in a public meeting. And so that's how easy it is to essentially slip into a violation with email. And so that's why you have to be very careful. And the third bullet point would be a violation of the open meeting law. Okay, so email, texting, or other electronic communications. We've touched on this. Open meeting law restrictions apply because the law includes gathering of a quorum through technological devices. So the type of medium doesn't negate the effect on the law, any type, and even as we move into the future, because technological devices is a very broad definition. So anything that comes out that is a new form of communication would still be captured under this open meeting law definition. So our suggestion is to avoid using devices among a quorum to discuss, deliberate, or propose legal action on a matter that may reasonably be expected to come before the council. So don't propose legal action. It only takes one council member to propose legal action, sort of like that example about, I think we need to sue. Well, that's one member proposing action. So it just takes one to be in violation if a quorum is present. And don't use technological devices to circumvent the requirements in the open meeting law. So let's recap what is a meeting, because there can be a lot of information there. So if all the requirements of what constitute a meeting are met, as the council, the open meeting law applies to you in your capacity as a public officer. So again, remember the purpose of the open meeting law. The public policy for open meetings is to inform the public about matters to be discussed or decided, because there can be a lot of frustration about the open meeting law and why you have to sort of have all these requirements and why you might be held back from talking to your fellow council members at certain points. But you have to remember that the open meeting law is designed so that the public can understand what it is that you're thinking, how or who is influencing your decision, and how you've made those decisions. So you're the representative. The open meeting law grants the public the right to attend and listen to those meetings. They can't do that if you're communicating by email or if you're communicating in a coffee shop outside of the view of the public. And so they have the right to attend and listen and understand how their council is governing their city or town. They also want to hear your voice, understand your deliberations, and know who is influencing your decisions about matters involving the city or town. So this is, again, where a lot of people sort of get frustrated because there's been a lot of don't do this and don't do that. But it is important to know that you can talk to certain people. So first off, it is okay to talk to other council members. And the thing that you have to consider is that you just have to make sure it's less than a quorum. So whatever your council is, whether it's 5-member council, 6, 7, make sure you know what your quorum is and that you're not deliberately trying to circumvent the law by splintering a quorum. But you can certainly talk to other council members. So for example, if there's someone that's on your council that has a really strong economic background and there's an issue coming up and you sort of their thoughts on it because you just value their opinion, you can most certainly discuss that with them. That's not a problem. Again, you just always have to be aware of the quorum requirement. You can also talk to other council members about action that's not related at all to the council. So obviously, if you're friends with someone on the council and you go to social events or maybe your families know each other, I mean, as long as you're not talking about council action and there's not a quorum, then you're more than welcome to, again, socialize with other members of the council. You can also talk to your staff, which I highly encourage. Your staff is there to help you and assist you, and they're very knowledgeable about the process. And so you can talk to your clerk, you can talk to your attorney, your manager, any of your staff if you're looking for information or recommendations on a course of action. You can always talk to your constituents. Obviously, they can contact you directly. You can contact them. Again, we just want to be careful that if they're contacting all of you in one email, that maybe you don't want to hit reply all if you're responding to them and beginning a discussion that could lead to an open meeting law violation. And then you can also talk to the media. So your First Amendment right is protected as a public officer, and so you have the right to go ahead and share that information with the media. And we'll talk a little bit about that because this is something that's been addressed within the past 10 years. So essentially, there had been some confusion for a while of whether or not someone could go out, let's say a council member, and that they could share their opinion with the media regarding maybe an issue that would be coming before the council. Because some thought, well, aren't you essentially disclosing to a quorum because the council can hear, what you said to the media, maybe how you're going to vote on a particular issue before you actually get to the council meeting. So the Attorney General's office had opined that the open meeting law does not prohibit a member of the public body from speaking to the media. And then essentially a couple years later, the legislature came back and codified that opinion and said public officials may express their opinion publicly if it is not principally directed at another member and is not part of a concerted plan to engage in a collective deliberation. So essentially, as long as you're not intentionally trying to circumvent the open meeting law and trying to relay how you're going to vote in order to circumvent the law, then it's fine for you to express your opinion publicly. And part of it is you have to look at the purpose of the open meeting law, again, is that openness and transparency. And what they don't want is, again, you discussing these matters behind closed doors to where the public doesn't know what it is, why you're maybe taking a particular course of action and how you arrived at a decision. But if you're talking to the media, you are essentially informing the public. You're letting everybody know what it is that might be influencing you. And so this is why the Attorney General's office and later the legislature decided that they wanted to make sure to protect your right to talk to the media. So we talked a little bit about social events. And these are essentially, if you have more than a quorum that'll be present at a function or an outing, sometimes some cities and towns choose to post what's called a courtesy agenda. And that essentially lists the event name, a quorum might be present, and then a statement that no business of the council will be discussed and no action will be taken. Now, this is not a requirement of the open meeting law. And really, this kind of up to your city or town to know whether or not this is a best practice for you. It works really well in some communities. They really appreciate it. I think the public looks at it and feels as though, yes, this is great. They're aware of it, on top of it, and they're reassuring the public that you're not doing anything to violate the open meeting law. But in other communities, it can be really difficult, especially in smaller towns where you're always bumping into each other. And so, are you really always going to capture every single type of event and be able to post this courtesy agenda? And that could be sort of become more of a headache. And so it's really your community that whether or not this is a best practice for you. So again, a courtesy agenda for a social event is not required, but it's just something to consider. Okay, so we've talked about how the open meeting law applies. As a council member, if you have a quorum and you're taking legal action, that's how you know it applies. And so let's move on to the council meeting itself. And so I kind of created a little map here that kind of talks to you about what we're going to discuss. So first we'll touch on the disclosure statement, which lets everybody know where your notices for your meetings will be posted. We'll talk about the notice of the meeting itself, the agenda for the meeting, talk a little bit about what happens at the meeting, including executive session, how it should be accessible to the public, the legal action taken, again, executive session, posting your minutes, and then any potential violations. Okay, so pre-meeting requirements. So before you even get to the meeting, there's a couple steps that you have to take. So first is your disclosure statement. So this tells the public where all meeting notices will be posted. So essentially, the notice of the meeting tells where you're actually going to be meeting for that particular scheduled meeting time, and then your agenda obviously talks about what you're going to be discussing at the meeting. So let's talk about the notices. Why do we even post notices? Well, this makes it possible for the public to attend the meeting if they so choose. It also informs the public of when and where the meetings will be held, and it also provides the means for how the public will get information regarding matters under consideration, because maybe they're not going to be able to attend the meeting, but they want to know what you're talking about, and they're going to look up the minutes later. So without notice, the goal of exposing public decision-making would be thwarted. So this is essentially from a case that discusses the the value of the notices to let the public know what will be happening at the meeting. So notices are a two-step process. So we have that disclosure statement, and then we have the public notice of each meeting. So your disclosure statement. So you have to conspicuously post a disclosure statement, and it has to identify the physical and electronic locations where public notices of meetings will be displayed. So this notification location must have reasonable access by the public and normal business hours, not geographically isolated, no limitations on access or it'd be difficult to find. So essentially when they really, and I've kind of highlighted conspicuously here, you really need to post your disclosure statement in a place where the public would be able to see it and access it easily. I know a lot of you have it right outside of your city or town hall. There's usually an area where you can put your notices. And so this is a good place for that. Also, you might want to put that on your website as well. And then public bodies, actually it is required that you put your disclosure statement on your website. And again, this is just important as we're moving into a more electronic age, that people can find out where they're going to be able to determine where your notices are posted so they know when your meetings will be held. You certainly don't want to put it on maybe a third floor or fourth floor or something where the public can't access it because you need a badge. I mean, that would not be somewhere where they could get reasonable access, or put it in a place where maybe the hours are maybe they're closed most of the time, and so the public wouldn't be able to get there until the evening. Again, you just need to make sure that it's somewhere that the public can easily access this information. So notices, the contents need to contain the date, the time, and the place of the meeting. So this includes your street address of the building and room number or any other specific identifying information. This is the actual notice for your meeting. So they have to be posted at least 24 hours before the meeting. This does not include Sundays or holidays. It only includes Saturdays if the public has access to the physical and electronic posted locations of those notices. So just be aware of that. So usually if you're having a meeting on Monday, then it's going to, like let's say Monday at 6, then you're going to make sure that that is actually posted sometime before Friday before 6, because it's going to have to be 24 hours. And unless you're open on Saturdays and the public can actually have access to those physical and electronic postings, then you're not going to be able to post on Saturday. So you need to do that by Friday. So your notices actually have to include the agenda, or if your agenda is not ready yet, they need to identify where the public can obtain the agenda. Now, usually the notice and the agenda are posted together just because the 24-hour requirement applies to both. And so it's usually doesn't make sense to post the notice too far in advance. But if you can't, I mean, that's fine if you can, if you want to give everyone as much notice as possible, but you need to let them know when they'll be able to obtain the agenda. Also, you have to post on the website. And then again, anywhere that you noted in your disclosure statement where you'd be posting that notice, you have to post notices at those locations. It seems sort of common sense, but it's just really important that you actually adhere to those locations in your disclosure statement. You also can provide additional notice of meetings as is reasonable and practicable, which essentially means if you have, access, public access TV, or maybe there's, I know sometimes in utility bills, you'll get meeting notice announcements in there, or newsletters, anything like that. Essentially, if you can kind of add it to something, then you're more than welcome and encouraged to do so. Now again, notices and agendas have to be posted 24 hours before the meeting, but there are 3 exceptions to that requirement. So the first is an emergency exception. Now, this is important to know that it actually requires an actual emergency. You will come under very heavy scrutiny if you use this emergency exception. So it truly has to be an emergency that you can justify and defend. So you still have to post notice, but perhaps it would just be less than the 24 hours. The second one would be if you're recessing and reconvening. So let's say you started a council meeting and you're going to the long, late hours of the night and you've decided that you're going to need to recess and come back. So you don't have to repost the notice, if you're just going to recess. But prior to the recess, you have to announce when you're going to resume, what time and place, or how you're actually going to notify when you're going to resume. And then the last one is ratification, and it actually requires notice 72 hours before a meeting, which is much longer. And so we'll talk about ratification a little bit more towards the end, and because this happens if you've committed an open meeting law violation. Okay, so that was essentially your notices. So you have your disclosure statement that tells you where you're going to post all your notices for your meeting, and then you have your notice itself, which talks about when the actual specific meeting is going to be held. The next is your agenda. And so this has to include the time, date, and place of meeting, and it has to list the specific matters that you're discussing and considering. So you can only take action on items that are listed on your agenda. If it's not on your agenda, you cannot discuss it. So that's important to know, because that, again, is where sometimes people slip into a violation because they maybe go off on a tangent on a topic that really isn't listed on your agenda. And you have to stick to those topics on your agenda. Otherwise, it's an open meeting law violation. And think of it in this term. Essentially, the notice and the agendas are there so that the public knows what you're going to be discussing. If you talk about a matter that isn't listed on the agenda, you've essentially taken that away from the public, the ability for them to know that you were going to talk about that particular topic. Maybe they would have wanted to be there, or at least check the minutes later. And so it's, again, this has to do with that transparency and openness to the public. It's very important that you only talk about what's on the agenda. So agendas have to contain information that is reasonably necessary to inform the public of the matters to be discussed or decided. And so there's definitely an art to writing agendas, because you want to provide enough information so that the public knows what you're going to be discussing, but you certainly don't want it to be lengthy. I mean, the agenda is supposed to be like a very small description of what you're going to be discussing. So definitely rely on your clerks and your attorneys to help you with the agenda setting. And if there's any type of doubt, again, all questions should be resolved in favor of greater disclosure of information. So the contents of your agenda, they have to include the specific matters, like I said, to be discussed, considered, or decided at that meeting. You don't want to use generic agenda items such as personnel or new business or old business or other matters. That doesn't really tell the public anything. You know, what personnel will you be talking about, or what is new business versus old business, or what is other matters? Those are just so general that the public wouldn't have any idea whether or not they'd be interested in attending that meeting. So I included in here a couple cases that kind of talked about cities that sort of came under fire for open meeting law violations regarding agendas. So the first was back in 1988, and this was a case where essentially the city of Phoenix had listed annexation items on its agenda, but they hadn't listed it specific enough with regard to one particular parcel. And so the city had essentially argued, no, we did put it on the agenda, but the court actually rejected the city's argument and said, you weren't specific enough. Like, someone needs to know, especially with annexation, you know, what parcel you're actually talking about. You can't just be generic. And so they essentially overturned the Phoenix ordinance that had annexed that land. So again, it can have dire consequences if you have a violation of open meeting law. So you want to be really careful when you're listing items, especially things like this, like annexation, anything regarding land use, that you're being very specific about the parcel numbers. And then this one was an attorney general opinion, and this was had to do with a school board member. But again, the law still applies. And this is where essentially a school board wanted to take action on an item that was not listed on the agenda. It just clearly was not on the agenda. Didn't matter, the attorney general said, if all of the majority of the members agreed to still vote on it, it was not on the agenda, and so it was a violation of open meeting law. And so anything that is a violation in that regard would be void. So again, it would seriously impact your ability to govern, especially if it was a contract, or as in the previous case, an annexation, something that you thought had already been resolved that essentially now was voided because of an open meeting law violation. Okay, so agendas can also include a report on current events. So essentially, the presiding officer, chief administrator, or a member of the public body may present a brief summary of current events. And I believe sometimes your city or town managers may also kind of fill this role. Essentially, what a current event is just to kind of provide a small briefing. You know, you don't want to take up everyone's time and have everything listed specifically on the agenda. You just want to update it maybe. But so the law allows you to do this, but with some caveats. So you have to make sure that the current event summary is listed on the agenda, that it is an item listed on the agenda, and that the council is not going to propose, discuss, deliberate, or take any legal action at that meeting on any matter in that summary, unless the specific matter is properly noticed for legal action. So essentially what you'd have on your agenda is you would have, current event summary or something similar to that. And let's say there's 5 items there that your mayor or your manager was going to present on. So they can provide sort of a briefing on all those events, but you as the council members can't start engaging in discussions or deliberations on any of those matters. It's really just sort of a one-way street. It's really communication just to you so that you, again, are updated on current events. If you want to talk about any particular matter that's being discussed in the current event summary, then I'd suggest that you, talk to your clerk and your attorney to understand how do you put items on future agendas. So that way maybe you can direct staff, hey, I want to talk about this in the future. So that way that can actually be addressed as a separate item down the road. But again, you cannot engage in discussions or deliberations if it's not specifically listed separately on the agenda. If it's just a topic that's being discussed under the current event summary, then you're just essentially there to listen. So we also have what's called consent agenda items, and these are typically used as time-saving devices when maybe there's items on the agenda that are non-controversial and really kind of ministerial in nature. And I kind of gave an example here of like maybe travel requests. You know, maybe you've had a number of invoices and things that just have to be approved, but it's not really anything that you would want to individually have to look at on the agenda. And so as a consent agenda, you can go ahead and approve it, just all of them together. Now you do have to still provide information, obviously the public understands what it is that you're going to be or not discussing, but you're actually going to be voting on, so that they're aware of it and they have that information. But essentially, again, it's just usually something that's going to be pretty quick that you just want to be able to easily vote on and as one whole rather than approving, maybe 15 different invoices or travel requests or anything like that. So you can just take one vote to approve or disapprove the consent agenda as a whole. Now, this is legal action, so again, it does have to be on the agenda as a consent agenda item. So I included here some agenda pitfalls. So what if you failed to properly list an item that the council was planning to discuss? Well, as I mentioned before, then you cannot discuss the item. If it's not on the agenda, then it cannot discuss it. If you do, it is an open meeting law violation. What if a council member begins speaking on a topic not listed on the agenda? Well, this is where you have to help each other out. And it can be sometimes uncomfortable or awkward, but this is where you need to remember that you as a council are a team, and they're there to help each other. And so you want to instruct the member to cease discussion on that topic. And if you don't feel comfortable doing that, or you're thinking in the future you might not feel comfortable doing that, then you need to talk to your city attorney and your clerk and find out what is the proper process. Who's watching to see if an open meeting law violation occurs. Is maybe your attorney there to kind of keep an eye on it? Will they raise an objection if they start talking on a topic that isn't listed? So just become more familiar with your processes and who is going to be speaking up. Because again, as a whole, if one member, starts talking about open meeting law or ends up creating an open meeting law violation, it could be the whole council itself that will have to face the penalty. And we'll talk a little bit more about that in a moment, but you certainly want to speak up if you know that there's a violation occurring. Also, you want to ensure that all members know how to properly place an item on the agenda, because most of the violations that occur are not intentional in terms of trying to actually violate the law. It's really just that sometimes they don't know especially if they're newly elected, what is the proper process to place an item on the agenda. And so you just want to make sure everybody is well informed of those processes. So what happens if you take legal action on an item not listed on the agenda? Well, the item is null and void. So if you approved a contract and that contract was not on the agenda, that contract is now void. And so you also will face sanctions by the Attorney General, which we'll talk about further. So now that we've gone through the notices and the agenda, now at the meeting, the important steps, of course, are to determine quorum to make sure that you can actually proceed with the meeting and take legal action. You want to record members present and absent. Yours also, I mentioned here, the parliamentary rules of procedure. Most of the cities and towns follow kind of like a revised version of Robert's Rules of Order. And, that kind of happens, you go through the chair to speak, and that's just so that it's a more orderly, you conduct business orderly. So just make sure that you're familiar with whatever rules that your city council uses. And then also at the meeting, typically the mayor would want to go ahead and list the agenda items and perhaps talk about what order they're going to, because you can change the order. Like, let's say that there's a large group that's there for item number 5 and you don't want them to wait maybe an hour or two, and so you want to move that up. So that's fine. Typically you just want to, as a best practice, let the public know if you're kind of reordering the agenda. After our meeting, so this is important, make sure that it's accessible to the public. Do not lock entrance doors. And I know, again, this is sort of a common sense, but it's happened before where it's just, things automatically lock sometimes, or doors automatically lock, and you don't realize the public can't get in. So just make sure that you always have access. And then you'll want to record motions and the maker. So what about the public, and what is the public's role in this whole process? So we talked about how the public has the right to attend and listen. So the council has to provide the public with access to all meetings. So essentially you can't inhibit attendance by requiring people to provide information before they can enter. You can't hold a meeting in such a remote location that they can't access it. Again, if maybe the doors lock at 5 o'clock and the meeting's at 6 and they can't get in, or maybe you're actually meeting in a location outside of your jurisdiction to where people can't get there because it's a gated community. Also, you don't want to hold a meeting in a room maybe too small to accommodate people. So again, if let's say you have an issue and you anticipate it's somewhat controversial and you're going to get a large number of crowds, then you're going to want to make some, you're going to want to actually create either extra space somewhere else, or a phone or video, or you're just going to want to be able to accommodate that large number of observers for that particular issue. Also, you don't want to hold the meeting at an unreasonable time. So again, you don't want to be, starting your meeting at 11 o'clock at night or 2 in the morning or something like that. It's one thing if you've started your meeting at a regular time, but maybe it's gone late, but you don't certainly want to start your meeting at a time where most people can't actually attend and listen. So a public body may make an open call to the public, so this is not required. Again, what's required is that the public can attend and listen, not necessarily speak. But I think most cities and towns, and it's a good practice, allows an open call to the public. So when someone does come in to speak, you certainly can ask them to identify themselves. Now, I just mentioned before that you can't make them sort of sign in and provide information to you in order to attend. But if they are speaking, it is important to ask them to identify themselves because this is information that will be in the minutes. Also, your open call to the public is subject to reasonable time, place, and manner restrictions. So, if you're going to limit everybody to 2 minutes to speak, then you just have to make sure that it's applied consistently, that you're not giving one side more time than another. Also, it's important that the public be aware that they can only address issues within the jurisdiction of the council itself. So if they start talking about, issues about the federal government or the state or something that again, is out of your control and not within your jurisdiction, then you could politely let them know that you're only able to address matters within your city or town. Sometimes it's best to just let them finish if they're almost done, but that's just something for you to be aware of, that really they're only supposed to be talking about matters within your city or town. Also, it's important for you as the council members to know that you cannot discuss or take action on matters raised during the call to the public if it's not specifically on the agenda. And this can be really frustrating for folks when, especially, the public is maybe talking about a matter that might be very important to you and is obviously very important to them, and they're really wanting and demanding a response. But if it's not specifically listed as an agenda item, it's not something for you to discuss. Again, that would be an open meeting law violation for you to talk about something that is not on the agenda. Now, you can respond to criticism. So if they're, let's say, are specifically targeting you as a council member, you do have the right to respond to that criticism. We highly encourage you to just let it go, only because it can sort of steamroll into perhaps further back and forth that maybe would not be constructive. But you do have that right to respond to criticism. You can also ask a staff member to review the matter or ask that the matter be put on a future agenda. But this, again, is you need to know what your rules and policies are for your particular city or town. So what about council members who want to attend the meeting by phone? Is that allowed? Well, it actually depends on your city or town. The statute itself doesn't actually mention anything about it. It's silent. So it's really up to your jurisdiction. And I know that some cities and towns do allow you to call in. Sometimes there's a cap on that. You can only call in 3 times a year, or or maybe 3 consecutive times or something like that. So check with your governing documents to see whether or not that's allowed. Obviously, it's best for you to be in person, even by phone, even with all of our technology. Sometimes it can be difficult to hear what's going on. So it's important that if you do participate by phone, the public does have to be able to hear the person on the phone. So it's not like they can be on a small speaker phone on your own individual phone at the dais. They really need to be probably on a conference phone so that everybody can hear it, and maybe even a mic needs to be near that phone so that the public can hear them clearly. The person on the phone has to be able to hear everyone at the meeting. So again, it's both ways. They need to be able to hear. And then participation on the phone has to be noted on the agenda and reflected in the minutes. And so this is where you need to know ahead of time, essentially at least 24 hours ahead of time, whether or not someone's going to be attending by phone. I do know some cities and towns kind of have some general language that allows, on their agenda that someone might be attending by phone. So that's something you can also look into, but it would be best if you can actually identify that, participation on phone is going to occur. And then it will also have to be reflected in the minutes, the member who attended by phone. So here's some meeting pitfalls. So I don't think that passing notes happens as often anymore with our technology. I think it's usually texting back and forth to each other. But this is something that we see sometimes, especially with texting. And it can be really disturbing to the public because they don't know what it is that you're talking about. You could be talking about something that is completely unrelated to council business, but they're going to suspect that you are trying to circumvent the open meeting law. It's just sort of, I think, human nature that they're if they see you up there on the dais and they can see a couple of you texting each other, that you are essentially talking to each other, without the public knowing what you're discussing, and they're going to assume that it's council business. So, just be careful of that perception. Probably shouldn't even have your electronic devices out if you're in a council meeting. Also, same thing goes for whispering, to council members. And then also, this is one where it's again inadvertent, but sometimes it happens like right before a council meeting, you have a quorum talking to individuals before the meeting officially starts, or maybe right after the meeting ends. And maybe you didn't mean to, maybe there's just a couple of you there, and then all of a sudden a third or a fourth joined, and all of a sudden you've been talking about council business with a constituent, and essentially now you have a quorum. So just kind of be mindful of your surroundings before and after a meeting. So we do have some exceptions to open meeting law. So, right, we've talked all about how it's important that the public has to be aware, they can attend and listen, and that your whole process has to be open and transparent. Well, there are exceptions to this rule. It is a limited exception. It's called executive session, and your agenda has to actually specifically state that you will be going into an executive session. If you don't, then you cannot go into an executive session. So it just needs to be clear ahead of time that you are going to go into an executive session, or that you anticipate you might. So let's say you're not sure. Let's say that there's an item on the agenda. You may need legal advice, maybe you may not. So if you think that you might, it's just best to go ahead and put that particular exception on that agenda item so that you have the option of going into executive session. Now you have to list the statute, but also you have to specify like a general description of what it is you're going to be discussing in executive session. And this is where your attorney really comes in to help you, because it has to be, again, enough of a description that the public understands what you're going to be discussing, but obviously not so much that it would hinder the purpose of the executive session, which is that the information is confidential. So this is where your attorney will help you and the clerk with the kind of general description on your agenda. Now, before you go into an executive session, the meeting or the vote to actually go into executive session has to be in public. So you'll essentially, in a regular open council meeting, and then there has to be a vote taken by all the members and a majority in order to go ahead and move into an executive session. So who may attend an executive session? So we get this question a lot. So obviously the council members themselves, they're entitled to attend the meeting. If you're subject to a personnel discussion, so that's one of the exceptions that we'll talk about, then you have the option of attending that meeting. The Auditor General, in certain circumstances, when they're conducting an audit, can attend that meeting. And then individuals whose presence is reasonably necessary in order for the council to carry out its executive session responsibilities. So typically you need maybe your clerk there to take minutes, unless you're going to have one of your council members take minutes. If you're going in for legal advice, then you need your attorney there. So it's really important, if you're going to have anybody outside of the council members in your executive session, that you actually list who is there and why they're there. Like you want to essentially justify their presence. And this is important in case there is an open meeting law complaint filed against you later, and someone essentially asserts that one of those individuals shouldn't have been there. The Attorney General will have access to those minutes, even though they're confidential. And so this is where it will help you with that particular complaint, that they'll see that there was a justification for that person being present in an executive session. So again, moving into an executive session, the vote to move into the session must be conducted in a public meeting. Now you can actually, we've had this question before where, can you just go ahead and make the motion to move directly into an executive session on a future date? And the answer is yes. So let's say you're ending a regular public meeting and you know that, there's a lawsuit that you're going to have to discuss, and you don't want to have to sort of open the whole council meeting, take the public vote, then move into executive session, because it does require a lot of logistics. You have to kind of ask all the public to leave, and you just want to directly go into an executive session on the next meeting. So you can go ahead and take that public vote at that current meeting for the next meeting. So that's fine. Again, it does have to be listed on the agenda that motion is going to be made, that you're going to be going into an executive session. Also, when you do make that vote and you're going to move into an executive session, make sure that the room is cleared. Only those authorized to be present are in attendance. So you want to actually take a quick scan of the room. You want to ensure that there's no belongings or recording devices left behind by the public. Also, council members should really put away their electronic devices. Again, aside from the official recording, if you're deciding to record, you just don't want to have any instance of any recording devices left behind or out in the open. So once in the executive session, remind all those in attendance that all discussions are confidential. And this is very, very important. So anybody who is in that executive session, they cannot discuss that information with anyone else outside of that executive session. To do so would be a violation of the open meeting law. So that's why also you want to really limit who is there. It really should be people who are reasonably necessary that have to be there, because just the larger the group gets, the easier it might be for an inadvertent violation to occur. So you just want to keep that group small. And again, always at every meeting, remind them that all discussions are confidential. So there are 7 statutory purposes for a council to meet in executive session. So again, courts have construed this very narrowly because, again, we want open and transparent meetings. And so it's important that these are very limited. So the first that I mentioned earlier was personnel matters. So if you have a discussion about either the employment, assignment, appointment, demotion, dismissal, salary, something like that, of a particular employee, so they're not talking generally, but just of a particular employee, let's say your city manager contract is up for review. So you have to give that written notice to the employee 24 hours before the meeting. So it's not that just the agenda is posted 24 hours, that's sufficient. You actually have to give a separate written notice to the employee 24 hours before the meeting that they're going to essentially, they'll be discussed in executive session. The employee may require the meeting to be held in public. Maybe they decided they want their contract terms and everything to be held publicly. And so that's something that they can ask. You may conduct a personnel evaluation in executive session, but as I mentioned before, this is not a session where then you can just talk generally about sort of all employees or about all salaries or, you know, the procedures for hiring or firing or anything like that. It has to be very specific to that particular employee. If you're going to start talking in length about, you know, generalities, then you need to move out of executive session and back into public session. And you can only discuss those matters if they are listed on the agenda. So again, the whole purpose of the executive session, it has to be very limited in scope. So it's really only about that particular employee. So the second reason or purpose that you can move into executive session is if you have confidential records that need to be discussed. So there are a long list in statute of records that are confidential. You know, certain maybe criminal history information, or maybe you actually need to look and discuss the executive session minutes from a previous meeting. Those are confidential, and so you can't discuss them in public. And so there also could be federal law requirements, like with a grant or anything like that, that requires limited disclosure. And so those are, again, some other items that you might need to just go into executive session to discuss openly. So public officials and employees should review the confidentiality provisions that affect their areas of responsibility to avoid disclosure of confidential information. So everyone should just be really familiar with their own individual scope of work. You know, if you're getting paid through a federal grant, you know, make sure there aren't any provisions in there that require, you know, confidentiality, or if there are, make sure that, you know, if they're going to be discussed at a meeting for some reason, that others are aware that that information is confidential. So the next 2 exceptions have to do with legal advice or attorneys. So if you needed to go into a session, let's say a lawsuit was filed against your city or town and you needed legal advice, so that would be one reason that you could go into executive session. Also, let's say you had a contract negotiation happening and you needed to instruct your attorney on you know, what they needed to do to perhaps settle. So that would be another reason where you could go into executive session. So the important thing about these 2 is that they actually have to be your lawyers. So just because someone is a lawyer doesn't grant them access to executive session. They actually have to be your lawyer. Or let's say you had to hire outside counsel for a lawsuit, then those lawyers are appropriate to be in the meeting. So, but they can't be lawyers for someone else. So if you're trying to negotiate a settlement or something, they can't be the opposing side's lawyers. They don't have a right to be at the executive session. So what is allowed? Essentially advice regarding the legal ramifications of the facts of the case, legal proprietary phrasing, drafting, validity of proposed legislation, including meetings, legal scope, and possible legal challenges. Essentially, your attorney is there to help you and to guide you with whatever matter is before them, to help you understand the ramifications of that lawsuit. But what is not allowed is discussion regarding the merits of enacting or taking, just sort of going essentially outside of the scope of the actual legal advice. That's not really the place for it. You're essentially there to get the advice from your attorney, and you can ask clarifying questions if you don't understand, what's happening with the lawsuit, or what the processes will be about the lawsuit, but you just can't really go beyond the scope about sort of the pros and cons and policy implications, because that's something that's more appropriate to in front of the public. So again, you always have to remember that executive sessions are very narrow, and so it's really just about, in this instance, what your attorney can help you understand about that particular lawsuit or whatever the matter is before them. So another purpose of why you can go into executive session is discussions or consultations with employee organizations for negotiating salaries, salary schedules, or compensation. So again, this is where you just have to remember that you have to stay very narrow. So this is about budgetary matters, program issues, or other items in executive session, like related specifically to this negotiation. So it's not a time where you can then start discussing a broad range of budgetary matters, that maybe, again, are more appropriate in a public setting. So you just never want to use executive session as a means to circumvent the open meeting law, which would be to essentially use an exception to then have a larger discussion that really should be in the public. So again, err on the side of caution, keep public discussions in the open meeting. And then the last two have to do, again, with more discussions or consultations. One is if you're having these consultations with international or tribal negotiations, or if you're doing any type of purchase, sale, or lease of real property. Again, it's really about the negotiation tactics, and it's not so much about the broader scope of the issue of whether or not you should or shouldn't be going into that negotiation or partnering with someone. This is really about the specific negotiation itself, and maybe providing instruction to your attorney about what they can and can't accept. So as I've mentioned before, minutes and discussions are confidential in executive session. So this is just really very important. You have to be very careful about this information, except for members of the body and certain other limited exceptions. So let's say you have a council member who was absent that day, that the rest of the council went into executive session. That council member can have access to those minutes. Again, they're a member of the public body. They have the right to go ahead and be informed of what occurred, because obviously they may need to vote on something later based on that discussion. And so it's okay for them to have access to that information. And likely they might want to even talk to their attorney or whoever it was that was present in the room and sort of get updated on what occurred. But again, they're under that same, they still can't share that information with anybody else. Also, it's important with your executive session minutes to keep them apart from the public session minutes to just avoid accidental disclosure, because there are times when people come and they request public records of your minutes, but you don't want to inadvertently give them your executive session minutes since those are confidential. So here's some pitfalls for executive session. Obviously, failure to keep executive session discussion confidential. Failure to advise persons about the confidentiality requirements. Again, you really need to do this at every single meeting. So whether that's the mayor who does it, or the vice mayor, or whether that's your attorney, whoever, somebody always needs to be charged with giving that, advisement in the beginning that everything is confidential. Also, best practices for preserving confidentiality. You don't want to probably email or fax or anything like that, these types of sensitive materials to members. If you pass things out to the council members at the actual meeting, you probably want to collect them right afterwards rather than have anybody walk away with them. And you as council members honestly don't want to have that information with you, because then the burden is on you to protect that information, that you have to make sure that nobody can have access to it. So it's really just best to provide all that information back to the clerk or the custodian so that they can handle it appropriately. All right, so let's talk about minutes. So this is just after your meeting. So this is, you've had your agenda, you had your meeting, maybe you went into executive session, maybe you didn't, but essentially, regardless, you do have to provide minutes of your entire meeting. And these can be in writing or they can be recorded. I know more kind of leaning towards recording these days. But essentially, your minutes have to be available for public inspection within 3 working days after the meeting. These are usually draft or unapproved because the council hasn't met again, and that's okay. They just have to be available to the public within 3 working days. And minutes should not be withheld from the public pending approval. You can always go back later after you've approved it and you can post those minutes again. If recorded, the public has to have access to that recording. If written in shorthand, it has to be typed or written in longhand. So again, it's just so that the public can easily access it and understand it. So your minutes have to contain the date, time, and place of the meeting, the members present or absent at the meeting, a general description of the matters discussed or considered, an accurate description of legal actions. So again, anybody who's made statements or presentations, if an emergency exists, the nature of the emergency, or if a prior act was ratified, a copy of the disclosure statement required for ratification, any of these types of issues, like these all have to be contained in your minutes. So they also have to contain the name of each person making statements or presenting material to the body. So I have here House Bill 2065. We haven't talked about that in a while, but this actually made some changes to minutes. And again, I think everyone was already doing this, but it essentially codified it, that the minutes now, once this law is effective in the summer of 2018, that it has to contain a record of how each member voted, a record of the names of members who propose each motion, and then any speaker who presents material to the council. Again, this was already, I think, being done in most jurisdictions, but I think they were just trying to clarify that they wanted to have this information in the minutes. So your minutes must remain on your website for at least a year. They are subject to public records law and record retention requirements. Your executive session minutes have to contain the same contents as your regular minutes, so any type of, what's been happening, any topics discussed, an accurate description of all instructions given to your attorneys. If holding an emergency meeting, a statement for whatever you were considering, and then any other information as appropriate. And sometimes, like I said, it seems a little counterintuitive to take minutes on a confidential meeting, but this is important in case there is an open meeting law complaint filed against you, that the Attorney General can review those minutes and hopefully exonerate you. So let's talk about open meeting law violation. So again, if a meeting is held in violation of open meeting law, all legal action is null and void. So as we talked about earlier about maybe taking action on an agenda item or an item that was not on the agenda, then essentially that action would be null and void, and that can have serious consequences. So let's say that happens, and it has happened in the past. So what can you do? So this is where ratification is effective. So essentially what it is that a council can retroactively validate a prior act in order to preserve that earlier effective date of the action. So a contract is the easiest one to explain. So let's say you had a contract that was approved by the council, but it had not been on the agenda. And so, that's brought to your attention later. And so essentially you have to have a meeting within 30 days after discovering that violation. And then you have to have special notice requirements. It's not enough to just simply put a regular notice out and a regular agenda. You actually have to have a written description of what it is you're ratifying, so you'd want to list that contract, a clear statement proposing ratification, and then where the public can get that information. And then you also, the public has to be able to access all deliberations, consultations, and decisions by members relating to the action. Because more than likely, you still took minutes or you still recorded at that last meeting, even though maybe you committed a violation. And so the public needs to have access to that information. And then it has to be posted, this special notice, at least 72 hours in advance of the public meeting at which ratification is taken. So most of the time it's 24-hour notice, but if you're ratifying, they want you to give the public 72 hours notice to be able to understand what the ratification is and how they can find out more information. So the good news is that ratification validates that prior action in order to make the action valid and enforceable. So if you go through all these proper steps and you ratify that contract, then essentially that contract is valid from that prior date, even though you essentially had done it in violation of the law. So that's great news in terms of your contract. It sort of preserves the enforceability. However, ratification does not eliminate your liability under the open meeting law. So the Attorney General's office can still enact civil penalties, and if they take you to court, attorney's fees against you for violating the open meeting law. So essentially, the AG has an open meeting law enforcement team, and they handle inquiries and conduct investigations and enforcement proceedings relating to any complaints, and they're assigned to their Government Accountability and Special Litigation Unit. So this is just a copy of what's online. Essentially, this is the open meeting law complaint form. And as you can see, it kind of just asks for basic information by the person making the complaint, who is subject to the complaint, the conduct that you believe violated the open meeting law, the date on which you believe the violation occurred, and then all the members of the public body whom you believe violated the requirements of the open meeting law. Because maybe this contract that was voted on, one council member was absent. So maybe they would list the remaining council members. And then there's a declaration here that under penalty of perjury that these are true facts. And then the ability to attach documents. So when a written signed complaint is given to the Attorney General or even the county attorney, they do have the ability to issue written investigative demands to the council, administer an oath or affirmation to any person for testimony, examine you under oath, and then examine by means of inspecting any of their documents, so any of the materials, minutes, recordings, etc. And this is just part of their investigative tool. And then if you fail to comply with their findings, then they could file an action in Superior Court for an order to enforce the demand. If you fail to comply, it could result in contempt of court, injunctive order against your conduct, and any other relief the court deems proper. Hopefully, we'd never get to that point. So essentially, there have been some changes here that have you can see the little red circle here with the exclamation point, and this has to do with that House Bill 2065. So they tried to clarify sort of that they differentiated certain actions. So right now, under current law, the Attorney General is essentially bound to essentially find the whole council in violation of the open meeting law. There's really wasn't a lot they could do to sort of target individual members who might actually be committing the violation. And so what this law does is it kind of clarified what we already had, which is that any person, be the Attorney General or a county attorney, they can always commence their own lawsuit in Superior Court to force compliance with the open meeting law. And this compliance would be against the council as a whole. And so this was essentially already in statute, but they did try to clarify some of that language that it was the council as a whole. This action can be brought against you in court. But House Bill 2065 also added some other provisions relating to individual members of the council. So now the Attorney General will be able to bring in action against an individual member of the public body who knowingly violates the open meeting law. Now, they are going to have to prove that, again, that you knowingly violated, that this wasn't an inadvertent violation, that you knew that it was in violation and you did it anyway. If they prove it, The first offense is that the court essentially has the discretion to impose whatever penalty they feel is appropriate. So that could be a civil penalty, that could just be individual training. That's for a first offense. A second offense will be a civil penalty of up to $500. A third or subsequent offense would not exceed $2,500. And a person can be removed from office, so you could lose your council seat if the court determines that you knowingly violated the open meeting law. So that is a remedy for them, so something to be aware of. And again, this can be brought against an individual member of the council. And in testimony, I believe what they had talked about, the Attorney General's office had mentioned that oftentimes it's not really the council as a whole that's committing these violations, and like they're coming up as sort of repeat offenders, but it's usually one particular person who might essentially be stirring up, stirring trouble and essentially wrapping in the rest of their council, or maybe the rest of their school board, because it's not limited to cities or towns. And so they've seen over a period of time that they were limited in being able to perhaps go after individual members who are really the ones who are knowingly violating the law. So this legislation is there in place to kind of help them with that. Also, this legislation will prohibit the council from paying or reimbursing the civil penalty for any member who is found to knowingly violate the open meeting law. So if one of your individual council members is convicted essentially of knowingly violating the law, and they say they get that second offense, and it's a $500 civil penalty. Well, the council can't pay that for them. The city or town is not on the hook for paying or reimbursing that penalty. It is squarely on the person who actually violated the law. Also, this legislation adds a safe harbor provision. It specifies that if who might otherwise be liable for an open meeting law violation objected on the record to the action of the body, that the court may choose not to impose the penalty on that person. And so this is, again, the benefit of speaking up, not only because really it's the right thing to do, but also now because it gives you an added protection under the law. If you are sitting in a council meeting and let's say an item starts being discussed that is not on the agenda, it is really very important for you to speak up, or again, to know what procedures are in place for somebody to speak up, to let the council know that that is an open meeting law violation, or you're going down that path, and that you should cease that discussion. If, let's say, someone says that and the other council members still decide they want to talk about it, or maybe they disagree and believe that it might be on the agenda, kind of tangentially related to another topic, you as an individual council member will now have the right to object on the record and say that you disagree and that you do not believe that it should be discussed, and that you think it might be an open meeting law violation. If it eventually is pursued by the Attorney General and gets to court, the court may look at your objection and sort of spare you from any penalty because they will note that objection. Now, it's not an absolute, it just gives the court discretion to, but that option had not been in place before this legislation. And so, again, I think the Attorney General's office in enacting this legislation is really to go after sort of those bad actors and to not rope in people who are sort of innocent bystanders, but are essentially still part of the council and have been facing the penalties together. So here's just some best practice tips. It's important to understand your role in the process. So if you're a council member, understand what the parliamentary rules and procedures are. How do you get an item on the agenda? Who do you talk to if you believe that there might be a violation occurring, or who will raise that issue? So it's just important. If you're a clerk, make sure that, again, you know what your role is during that meeting. Same thing with the attorney. So everyone just needs to understand what their role is in the process. And really, you want to kind of discuss this now before you actually get to a meeting, and you don't know, whose responsibility it is to maybe mention or raise an issue. Also, it's important to stay up to date on the law. So trainings such as these are really helpful because it kind of keeps you informed of what's been going on in any new legislation, such as House Bill 2065. So also, sometimes, it's not as often as you have these open meeting law trainings, like maybe you're newly elected and then it's been a few years, you can always request a refresher. So we're always more than happy to come back out and give us, shorter presentation to your council. You can watch, kind of rewatch these on webinar or YouTube, just to, again, to have a refresher and stay up to date on any changes. Also ask questions, make sure that you ask your clerks, your attorneys, your fellow council members. You can always ask us here at the League if you have questions about the open meeting law. So here's just a list of essentially all the statutes that make up the open meeting law. The ones that are highlighted in red are the ones that have been changed by House Bill 2065. So I just kind of wanted to make a note of that for you. There are some additional resources. So the Arizona Agency Handbook, Chapter 7 is all about the open meeting law, and I've referenced it a few times today. And so this is online, and it's easily accessible. I have the URL there, but you can also just go to azag.gov, and you can find this agency handbook there. Also, the Ombudsman's Office, they're a part of the legislature, and they do a lot of open meeting law and public records law trainings. And so they have some good resources, including a newsletter. And so I'm sure they'll be keeping up to date with all of the new legislation as well. And then, of course, for us here at the League, you can always contact us. So my contact information is there. Again, if you have any general questions about the training or just open meeting law in general, please feel free to contact me, and I'm happy to get back to you. If it's a very specific question about what's happening in your city or town, or maybe you think there was a violation that could have occurred or may have occurred, then I strongly suggest that you talk to your attorney first. Your attorney is then more than welcome to contact me. So that's all we have today for open meeting law, and hopefully this was helpful to you. Again, feel free to contact me if you have any questions. Thank you.